Okay. Saving some time from Anna, I'm going to start recording. Hopefully you can hear me. Miodrag and Dragica are trying to steal as much of my time as possible. So we are now, like, if we want to be on schedule, I have to speak for 35 minutes. Which won't happen, obviously. I'll speak definitely more than 35 minutes. Not much more, hopefully. So, yeah, at one point we should go to sleep. These are important topics, but still, sleep is important too. Okay, Dragica was telling you about some basic concepts in feminism as a theory and ideology. And in feminist jurisprudence, Miodrag was telling you about some ways of situating the relation between law and gender within legal studies and within law. And I'll tell you about feminist legal theory or feminist jurisprudence. Now, my idea for this lecture, and we could have been better coordinated, we weren't, is to make little boxes for you in which you can fit some knowledge about feminist legal theories that you acquire during these 5-6 days. That's the first idea. The second idea is to tell you about a Netflix show. Well, so we'll see which one goes better with you, and we'll see about your comments. But the idea is basically to run you through some of the most important ideas in feminist jurisprudence and to explain what feminist jurisprudence is. Now, in order to do this, I'm a legal philosopher. One of the vices, the same vice that Miodrag has. So I'll be talking about this in legal philosopher terms, but I won't be doing it analytically. I'll give you an overview of topics, and if you want, you can always dwell on the topics by yourself or by studying general law in the master studies that will hopefully start in a couple of years on the Faculty of Law. Now, in order to explain, and I think that I disagree kind of with Miodrag's approach to this relation between law and gender. I think in order to understand the relation of law and gender, you have to understand what jurisprudence, what legal science does. And what legal science does is basically something that we can call insider jurisprudence on one side and outsider jurisprudence on one side. Now, for all those of you who are lawyers, mostly during your studies you did something called insider jurisprudence. And this is completely understandable. I'll explain you why. You didn't do much of the thing that is sometimes called outsider jurisprudence. Insider jurisprudence is something that we usually call descriptive and normative theory of law. So this is the thing that you've been doing in Introduction to Jurisprudence, for example, but also in all of the other courses that you had within your legal studies. Traditionally, jurisprudence and even legal science provides a general philosophical and scientific analysis of law and legal institutions. Legal concepts like marriage, or like contract, or like criminal law, or like punishments, and so on and so on, or whatever you can think of since the Roman times and even before that to today. Now, analytical and descriptive jurisprudence analyzes
I'm sorry for interrupting you, but we can't hear you.
Thank you.
Yeah, I'm terribly sorry to all of those who were online not hearing anything. How could I do a brief recapitulation?
By starting all over.
Yeah, just with the exact same words. But hopefully this was recorded somehow. But I'm terribly sorry for the technical difficulties for those of you who are online. Anyway, I just started talking about the topic, and I made this difference between insider and outsider jurisprudence, and I'm talking about insider jurisprudence now. Now, this analytical or descriptive insider jurisprudence basically tells you something about legal concepts. It explains legal concepts, it defines legal concepts, it relates those legal concepts to other concepts. So basically the entire time, the insider jurisprudence and analytical jurisprudence is within the law. There is also a branch that we can call normative jurisprudence, which from a legal perspective tells you how legal norms should look like. For example, when somebody tells you that that tax law should lower the taxes to the unemployed or eliminate the taxes to the unemployed, somebody is doing normative jurisprudence. Now, both descriptive and normative jurisprudence are insider jurisprudence because they are done by lawyers and they are done from the perspective that is internal to a legal system. So we're not stepping outside of the legal system in order to evaluate something. We're just discussing the ways in which a legal system operates or should operate. And this is completely understandable. When you go to a lawyer and ask him for advice, you don't want him speaking about, for example, property in Roman law in the 1st century BC. You want him to solve the problem that you have with property law of Serbia in 2023. So we teach students how to handle contract law of Serbia in 2023. But that's, of course, not the entire story of scientific or jurisprudential or legal philosophical analysis of law. That's why we talk about something that's usually called outsider jurisprudence. With this outsider jurisprudence, it is often called critical theory of law. Now, you shouldn't understand this critical like something, law is always something to be criticized. No, basically it's a position that we take when we analyze law from the outside. So a traditional position of somebody who analyzes law from the outside is, for example, the position of a sociologist. You don't go to sociologists to represent you in front of a court of law. But you go to a sociologist or to a historian to answer the question of, for example, why are our contemporary legal rules such as they are? Or how did our contemporary legal rules came to be? And so on and so on. Now, from this critical theory of law perspective, law is usually viewed as a kind of emanation, a kind of, if you will, a social entity that came about because of certain power relations within a society. It arose out of a social context and certain relations of power. Now, critical jurisprudence or critical theory of law or outsider jurisprudence seeks to expose, understand, and challenge how the law has historically been used most of the time to maintain power and privilege for certain groups and promote a more just and equitable legal system. So that's the idea of this outsider critical jurisprudence. Now, again, you haven't studied much of this because you studied to become lawyers, not sociologists of law, not historians of law, not philosophers of law. You studied to be lawyers, of course, with the caveat that not all of you are lawyers. Those of you who have studied other humanistic disciplines, for example, history, the colleague mentioned, have a bit more of this other perspective, this critical, this outsider perspective. Now, this outsider jurisprudence, what is peculiar about it's that it's not singular. There have been movements within critical jurisprudence or outside jurisprudence that have dominated the discourse in jurisprudence in the last 100 years approximately. Most of them have started, at least in the Anglo-American world, with something called realist jurisprudence. I won't go into this history of legal theory, but they started with American legal realism, for example, in the United States, with free law movement and sociology of law movement in the United States and in Germany, and so on. But for our sakes and for the sakes of these lectures, the most important strands of this are critical legal studies, feminist jurisprudence, critical race theory, and queer legal theory. So what is important for you to know, and you have my presentation online, and I want to keep it as short as possible, is that feminist jurisprudence situates itself basically as an outsider jurisprudence, as a view on law that explains and criticizes law from the outside from a certain perspective. Just like critical legal studies, just like critical race theory, just like queer legal theory. And here we go with this simple definition of feminist jurisprudence that I'll be using in this lecture. So feminist jurisprudence is a branch of jurisprudence focusing on the ways in which law has historically and continues to discriminate against women. And I'll be talking about feminist jurisprudence mostly. I won't be dwelling today in this lecture on gender issues, so I'll, for the most part, be out of Miodrag's conceptual analysis of the relations between law and gender. Feminist legal theories argue that law should be reformed to address gender inequalities. So basically, if you are on one of these positions, you're colloquially called a feminist. Now, how many of you, and I need this for the continuance of the lecture, how many of you think of themselves as feminists? A raise of hand would be enough. How many of you think of themselves as not feminists? Okay. And how many of you are really reluctant to even hear the word feminism and use the word feminism? Okay. Okay. So, at least one true answer. Maybe there are others. Now let us go to feminist jurisprudence and explore some of the nuance in feminist jurisprudence and in feminism. But before we do this, I want you to meet a lady called Lydia Poet. So if you're an avid watcher of Netflix series, you saw that there is a series called probably also Lydia Poet. And I'm telling you the same story with a slight difference that my story is true and that's completely made up. Now the story goes like this. On the 26th of August of 1855, in Traverse, province of Perero in Italy, Lydia Poet was born. Her family was rather wealthy, rural landowners, like most of the people in Italy at the time. She had 4 brothers and 3 sisters. She was the last one. After spending her childhood in her hometown, she moved to Pinerolo with her brother Enrico, a lawyer. People watching the series saw that this is actually true also in the series. In the city, she studied and obtained a license to be a school teacher, was later sent by the family near the Lake of Geneva to study English and German. She studied English and German, learned English and German with flying colors, passed all the exams. In 1977, she enrolled at the Faculty of Law, University of Torino, or Turin. Now this story, maybe if they are Italians and I can't see very well here, should be at least known to them, but also to you others. The possibility of women studying faculties was introduced some, I think 3 or 4 years before she enrolled on the faculty as the first woman who was enrolled on the faculty. And she graduated. Unlike many of the students of the Faculty of Law, today she graduated in 4 years in 1981 with flying colors. So her experience, and she told this in a large interview in Corriere della Sera, was fantastic with studying. She had a lot of supports of colleagues. She wasn't viewed as the single woman there studying. They were all kind of supportive, moving with her, cheering for her to finish the faculty, everything. Now, after graduating, she enrolled at the Register of Trainees, Practitioners of Law, and then did 2 years of practice at Pinerolo in an office. So she practiced for 2 years as a law clerk, doing whatever law clerks probably even today do, so grabbing some food and stuff like that. Now, in '83, after 2 years of practice, she passed all the necessary examinations to become a trial lawyer, avvocato in Italian, as prescribed by the 1874 law. So all requirements were passed. And she applied to be enrolled in the Bar Association. Now, the application arose great surprise in legal circles of Torino and provoked, of course, controversy. But this debate ended in the Bar Association with 6-4 votes in favor of Lydia Poet becoming a trial lawyer. This was noticed by the general attorney at the Turin Court of Appeal, who opposed her enrollment in the bar, and in '83, the Court of Appeal upheld the Attorney General request. After a 3-year trial and a public debate, the Turin Court of Cassation confirmed the decision. So, let us see how you become a trial lawyer at the end of the 18th century if you're a woman. You finish a faculty of law. You pass the bar exam. You get an inscription in the Bar Association. You fulfill all the legally required criteria. You personally fight in court and in public for 5 years. And the Turin Court of Cassation says, we are sorry, but le donne non possono fare l'avvocato. Women cannot exercise the legal profession. In other words, there is no way for you to become a lawyer in Italy at the end of the 19th century, even if, strictly speaking, it's allowed by the law. Now, enter feminist jurisprudence. And we're going to differentiate between 3 kinds of feminist jurisprudence: liberal feminism, radical feminism, and intersectional feminism. And I'm going to explain, by using the story of Lydia Poet, these 3 kinds of feminist jurisprudence. Now, liberal feminist jurisprudence. These are the main ideas. Now, the situation of Lydia Poet, liberal feminists would say, can be remedied. This injustice, seems to us obvious injustice, can be remedied by legal reform. So that's the main idea of liberal feminist jurisprudence. If we make a legal reform that basically explicitly states, or change the law to explicitly state, women, like Lydia Poet, are allowed to be inscribed in a bar association and are allowed to become trial lawyers, we solve the problem. In other words, the idea of liberal feminism is legal reform which is conducted within the existing legal and social structures. So we'll advocate for a change of law. La legge forense is called in Italian. We don't have it. A statute on legal professions would be the translation in English, I think, although we don't have anything, I think, similar. So basically, if you're a liberal feminist, your idea is to advocate for equal treatment under the law. Now let me just go through quickly some of the key ideas. So equality of opportunity is one key idea. Women and men should have equal opportunities. In our story, the equal opportunities are concerned with the possibility of both men and women becoming trial lawyers. This should be done through legal and political reforms, and law should be gender neutral. So there shouldn't be gender-based differences in law. Okay. with these key ideas, there are some modes of action or ideas of liberal feminists. How should this be achieved? And the basis for the achievement of this, according to liberal feminism, is reasoned dialogue, public dialogue, debate that should lead to legislative changes that would equate men and women. Now, these incremental changes, incremental, you know the meaning, so easy step-by-step changes, should be done within the existing social, political, and legal arrangements without radical or revolutionary transformations. How does this sound?
Nah.
Does it sound okay?
No.
Okay, it sounds okay. I'm asking, I'm asking the colleague, yeah, okay. Now, so, let me tell you and move a bit further with the story of Lydia Poet. Of course, after being denied inscription by the Court of Cassation, you cannot appeal to anyone else. It's the highest court in the country. Italy at the time had 4 courts of cassation, so she gave up on the profession of trial lawyer and continued being a member of it's the first International Penitentiary Congress. She served as a secretary, as an Italian representative. The French Academy appointed her. France was a bit different at the time than Italy, but historians will tell you about that. I won't dwell on the differences between countries. So she basically continued to work on law, but not from the perspective of a practicing lawyer. She was eventually inscribed in the Order of Lawyers, and she became a trial lawyer in 1920, some 40 years after she appealed to be a trial lawyer. At the time, Lydia Poet was 65, so basically retirement age. And she did so thanks to something that happened basically because of liberal feminism. Thanks to a law that's called and famous in Italy now as the Sacchi law from 1919, that law explicitly opened the space for women to have professional careers as trial lawyers. So 2 years later, in 22, Lydia Poet became president of the Women Pro-Voting Committee, founded in Turin some 10 years ago. As you know, for liberal feminists, and Dragica was telling you about these waves of feminism, I won't repeat it. In the first wave of feminism, the biggest issue was not becoming trial lawyers, it was getting the right to vote. She died some 20 years later after becoming a trial lawyer, never exercising, of course, the legal profession given her age, at 94 in 1949. So, recipe for becoming a trial lawyer. Again, according to liberal feminism. You finish the faculty of law, pass the bar exam, get an inscription in the bar association, fulfill all the legally required criteria. Argue for a change in the law to include an explicit rule now, allowing women to exercise the legal profession. Wait 40 years, congrats, you're in. There seems to be an obvious problem with liberal feminism. Can you spot it? Can you formulate it in a way that's not so jokey in the way I formulated it here?
It takes time.
Yeah, if it works at all.
Wait
Yes.
for Rosa Luxemburg.
Yeah, or a historical figure that saves a soul. And yeah, I've never believed in these like Machiavellian and Nietzschean ideas of historical figures saving everybody. But the problems are kind of obvious. So it is one thing to change the wording of the law. It is quite another thing to solve a problem that the group has. And now this is an obvious thing. It seems an obvious thing. And you'll see why this is an obvious thing, because I'll continue with the story of women in law and trial lawyers in Italy. In other words, Other branches of feminism that I'll tell you about usually consider liberal feminism as as necessary, but quite often impotent, especially to solve certain problems that a generation of women has. Okay. And like, of course, also nice caricature, like patriarchy and liberal feminism, who just paints the patriarchy in different colors, because the legal changes, and you living in Serbia, you know it now by now, legal changes are usually just some makeup.
Yeah. Cover.
Yeah, some cover for some deeply rooted inequalities. Now, enter radical feminist jurisprudence. The ideas are different. Law is not seen as a tool like in liberal feminism. Law is seen as an oppressor. That's the main idea. So it's not enough to use law to incite change that might come when we change the law and might not. But the idea is to completely restructure society. Because, and Dragica was telling you about this, so I won't dwell on it, current legal systems are patriarchal. They are basically designed to perpetuate gender inequality. Now, radical feminism wants to challenge this patriarchal construction of the law and to challenge traditional gender roles. Now, these are the key ideas, and you can notice them from these things that I was telling you about. Radical feminists speak about patriarchy, about sexism as a system of oppression, about the rejection of traditional gender roles. They focus not anymore on legal changes, but on female experiences, especially in the domain as reproductive rights, control of reproduction, and there is also an important topic, which is the criticism of male violence. And now in this radical feminism, you notice some of the topics that are also today actual or let's say trendy, in a lack of a better word, also in Serbia. Now, the modes of action are not dramatically different, but they kind of adapt to this new idea. And the idea is direct action. So it's not just changing the law anymore, it's also teaching, it's also striking, it's also protesting, it's also educating, it's also training, it's also giving legal services to women. One of the effects of radical feminism are women's societies, some societies that help women in certain situations, that protect women against violence, or that offer safe houses to women, and so on and so on. So the approach is much more involved, and law can help, but usually doesn't. Usually it masks some deeply rooted differences, and not just masks, it kind of fortifies them, it solidifies them. Okay. So, story of Lydia Poet. Saki law in 1919 allowed women to become lawyers. So you would expect that by Second World War, in Italy had at least X% of lawyers. Well, not really. In the 80s, in 1980s, a full 7 decades after Lydia Poet was admitted to the Chamber of Trial Lawyers, there was no more than 10% of women trial lawyers in Italy. So in 70 years, the number from 0 rose to 10%. The only increase noticeable came in the 90s. Today, in 2023, according to the most recent data, there are more female than male trial lawyers in Italy. Okay. So, and that's the meme. So the idea is, okay, we changed the law, what? Now everybody can become a lawyer. Well, not really. So it took 70 years of this. Now let's see the recipe according to radical feminists. This is the poster that I like, the socialist poster, fantastic. So, still, finish the faculty of law, get an inscription in a bar association, do everything that's required by law. Now, change existing laws, change the legal system, add more laws, according to the ideas of radical feminism. Fight vigorously for 110 years. Congratulations, most women who want to get in are in. Now, the problem. Radical feminism obviously moves from the liberal feminism equality of opportunity to change somehow the social structures that reinforce this disparity between men and women. And radical feminists did a good job with this. But the usual criticism of radical feminism, and probably also the reason why most of you here do not consider themselves feminist or even have negative association with feminism, is the insistence on differences between sexes, the insistence of equality, the ways or modes of activism, the visibility of this activism, the insistence of some forms of oppression, the insistence of women's rights, on disparities between men and women. And still today, this is usually perceived in this way, even for some reason by women and not by men. I'm not sure about the reasons, and it would take a psychological and sociological assessment of this. But most of the tactics of radical feminism, I think, have led to certain impressions of feminism, because even the colleague who was repulsed a bit by the very term feminism agreed in various ways, or at least agreed with the ideas of liberal feminism. But as with everything, certain results wouldn't have been achieved without the tactics, the ideas, and the movements and the actions of radical feminists. Another way of criticizing radical feminism is a criticism from within, from other kinds of feminism. And the idea was that radical feminism has a too essentialist view on gender, for example, or feminist jurisprudence. This basically means that they separated neatly the world into male and female, disregarding other gender issues that are becoming quite important, and we've been talking about that. Also, the issues that were neglected were also LGBTQ plus issues, as well as issues stemming from different classes. The essentialization of this difference between men and women has led radical feminists often to disregard all the other modes of discrimination that individuals within a society face. And not just discrimination based on gender, but also discrimination based on other qualities or lacks. For example, discrimination based on race, discriminations based on age, and so on. This was especially class. But I won't be talking about socialist, but it's kind of close to radical. This is why intersectionist feminism emerged, kind of. Now, from the perspective of intersectionalist feminism, or feminist jurisprudence at least, law is not a tool, law is not the oppressor, law is kind of a patchwork of discrimination. So the idea is that you cannot basically view one kind of discrimination as isolation from the other kinds of discrimination. But discrimination within a legal system should be analyzed comprehensively. And there are various grounds for being discriminated against within a legal system. And we know these grounds. You could be discriminated because you're a Roma, plus because you're a Roma woman, plus because your husband is maybe in prison, plus because you have 5 kids. And according to intersectionalism, disregarding any of these or claiming that a Roma female is discriminated against just because she's female is a serious omission both in the analysis and in the action that should bring about equality. So, intersectionalism basically emphasizes the interconnected nature of various forms of oppression within the legal system. And kind of this, even for those who dislike the very idea of feminism, this kind of rings true. You might be discriminated against if you're a wealthy white person living in a new Belgrade area. But it doesn't seem that you can relate to a person who's a non-white Muslim person living in a rural area without access, for example, to running water. It would seem obvious that the position that one finds himself or one finds herself in when we have these multiple forms of discrimination is worse than the position objectively worse, societally worse, psychologically worse than these other, than when we have a single line of discrimination. Now, key ideas. Of course, intersecting forms of oppression. Of course, inclusivity and diversity as the basis of action. Challenging essentialism, like it's not just women and men anymore, it's women of a certain class, it's transgender people, it's dependent highly on race, on social status, and so on. So the groups are not homogeneous anymore. It's not just this homogeneous group of women, this homogeneous group of men, but various instances and various intersecting, that's why you call them intersectional. Various intersecting identities play a role, someone being discriminated against within a society. Still, criticism of traditional legal frameworks, legal reform, policy development, it expands the focus of feminist legal theory. You'll see all this in my presentation, it's already there. Now, the ways of acting are not so much different from radical feminism. You can't do much more. But feminist movements start to collaborate much more with other social justice movements, like movements of racial justice. So you saw it in movements such as Me Too, or the movement in Serbia that's to stop femicide, which is a recent movement, and many other world movements that kind of combine these various lines of discrimination. But to continue the story of Lydia Poet, in 2022, when there is more than 50% of trial lawyers in Italy, what's there more to ask? Isn't it now done? So feminists pack their bags and just go home doing whatever they want, being trial lawyers and stuff like that? Well, not really. The problem is that even if there are more women in Italy than men, they are underpaid systematically. So they earn less than men, even if they do the same amount of work. Then, Italy is not a small country.
Please, can you explain this? I don't understand. How are they underpaid?
So,
This
yeah,
comes up and I don't understand.
I'll explain it just to make sure to finish, and we'll do it in a Q&A. But the basic idea is that women earn less than men doing the same job. Yeah, it's like you. Yeah, that's it.
How is it? I mean, the hourly rates are the same. I don't understand how.
Well, usually not.
No.
Well, usually not. But that's one way of doing it, not having the same hourly rates. But there are other ways of doing it, but they earn less than men on the same profession. Okay. Also, geographically, this is problematic because, as you might notice, there is that funny depiction, especially of Italy, like every graphic in Italy, south of Italy is red, north of Italy is blue. So yeah, usually all the good things are in the north, or all the bad things are in the south. As one might imagine, women in certain parts of Italy, for example, but also in certain parts of Serbia, are deprivileged and can only dream of becoming trial lawyers, like Lydia Poet dreamt in the end of the 19th century. And also you have certain categories of women are prevented legally and socially from achieving their potential. For example, yeah, let me speak about Italy maybe, but I could also do it, since it's an Italian example, but I could do it, I didn't do it for any other reason than I wrote about this example. That's the reason. But for example, the black community and the females for the black community in Italy are disadvantaged compared to white women. Okay, so when you're in the intersectionalist, the recipe: you finish a faculty of law, get an inscription in the bar association. Congrats, women are in. You take a look around and try to notice who else is in. And you notice that that might be that it's too white, or might be that it's too rich, or might be that it's too straight, or might be that it's too privileged. And that is basically intersectionalism. The opportunities are there, but still, if you're a member of a certain privileged societal group, even if the law removed all the obstacles for you to exercise a profession. Now, an obvious problem with intersectionalism is that it's complicated, which makes it difficult. Which makes it difficult to advocate for, and that this could be also one of the reasons why many people, when you mention intersectionalism in terms of feminism, are inclined to reject it wholesale. But some of the ideas, especially this ground idea that various forms of discrimination combined discriminate more against somebody than one form of discrimination does, obviously it contributes both to our understanding and to our possibility to address certain issues. And finally, a thing that I don't know it will be surpassed ever, it's the overemphasis on individual differences. Like, I don't see this being ever changed. This will be a permanent problem of these approaches, because the way things stand now, completely idiosyncratic positions want to become part of, or are advocating for becoming part of law and changing law in order to suit or to accommodate for these very, very small groups. It's not for lack of wanting to accommodate, it's for the fact that law has this peculiar thing that is general and has to regulate an indeterminate amount of relations. So nobody makes individual laws. If you make individual laws, you're not a democracy anymore, you're not a rule of law anymore. At best, you're a kind of a police state. Okay, so what is there to theorize about today in terms of feminism? It's obvious that as an outsider jurisprudence, feminism put a strong emphasis on inequality. So that's the basic idea, based on certain criteria. It started as this idea where inequality is based on sex, but it developed into this idea where all kinds of inequalities should be subject to a certain scrutiny. So nowadays, it would seem that even if it's all commonly rejected, feminism is kind of this ideology that consistently fights against all kinds of inequality within a society. It moved from this formal equality into this substantial equality and rejected the idea that everything can be solved by the law with radical versions of feminism. Some inequalities are maintained by law, and these inequalities maintained by law make it almost impossible or improbable to solve, but it stays as a fact, irrespective of what you think of feminism and of its various strands, that law has to have this one permanent moral task: to reduce the inequalities that are the most entwined or forcefully held within a society. That's it. Thank you.
We have some questions in the chat online. And I said that we will address these questions in Q&A session.
Yeah, that's reasonable, I think. Just a sec. I'm going to stop with this. We can start, I think, the Q&A. Do you want to moderate, Dragica? Just the same.
We will moderate together. So just read those
Yeah, okay. We had some
comments
questions.
or questions, and then we will see what we can do.
Okay, the first
In
comments
20
are
minutes.
my fault because you couldn't hear me. The others are okay.
This one, do you think that constitution should protect women? Like in India, there is a special provision for women in constitution.
Absolutely, I don't know in which respect, but there are many reasons for. There's this weird thing when it's kind of this
Constitution protects equality, but then these particular laws on gender equality against discrimination, they make it more concrete.
So
But
there's-
constitutionally,
Yeah, there's this problematic thing with autonomy and legal protection. The thing is this. So absolutely, there are certain differences, both social and biological, that law can address. Obviously, as you saw from my presentation, law cannot address all inequalities in the sense of solving them, but it can influence these inequalities for the better. Some inequalities are for various reasons addressed by law by giving women certain rights. For example, this is certain rights that men are not given. These are usually rights related to children, reproductive rights. These are the usual rights granted to women. And some privileges. And some privileges. We never discuss anymore these privileges. We take them for granted. But for example, women usually don't serve the army. Many countries in Israel, they serve. There are some privileges and some rights connected to these privileges. Now, when you protect or give certain rights by law, there is this thing in which it becomes heavy-duty paternalism when you overdo this. And I'm not entirely sure that it is for the betterment, for example, of women. The absurd increase of all kinds of protections, rights,
and
immunities,
women
and
are
so
against
and usually, of course, there are different views. Yeah, because basically, at one point, you have to ask yourself, where is is the law, by giving me all this, is the law practically negating my autonomy? So is it negating my autonomy? Can't I decide on this, or everything has to be granted to me by explicit legislative enactment? But that said, constitutions absolutely have to, it is one of the fundamental tasks of constitutions to regulate these relations or to confer these rights to women, which are I can't pronounce this word, inalienable.
Unalienable.
Or whatever.
Everyone should.
Probably, yeah. Let's all try. Well, No, but definitely,
Inalienable.
especially in certain respects, like reproductive rights, and I don't have time to argue for this. You know,
Inalienable. Inalienable.
inalienable,
Repeat now.
inalienable.
Kao alien. Ne,
Thank you, Professor Ivanović. Certain rights that are related, especially to
Make it
reproductive.
short in order that we can
What time is it?
see what are the other questions and maybe
I have another
some.
question in the chat.
Okay, which one?
Do you think it would be right to exclude the gender approach and thereby show that we are all equal in human status?
We are all.
Do you think it would be right to exclude the gender approach and thereby show that we are all equal in human status?
Of course not.
There is something called affirmative action.
Can I say something related to the previous remark as well? A simple thing we can ask ourselves, and usually students of law do learn what substance belong to constitution as the highest act. So I think the question was phrased in such a way, or at least I read it that way, whether this special provision belongs to the constitution as such, as the highest legal act. We know that there are kind of typical provisions that we nowadays, historically speaking, connect to the substance of the constitution, but each country has numerous specific provisions due to particular historical, socio-political reasons. And I would say, from all I know as an outsider about Indian experience with treating women, that it's a very good first step to have a provision in the constitution that protects women just like a special subset or special legal class of legal subjects. But obviously that's one thing. It's one thing to put a provision, it's another thing what we get by the end of the day. And that was the whole story of Bojan's presentation. And we all know from other areas, and most of those stories that we know belong to the stories about certain minority communities that are minorities on the basis of either social status, not necessarily numerical minority, but in terms of social status, like like women or the ethnic community or other communities. So most of the stories that we know, even with the law at place, we usually had a history of fight for these laws to be implemented. The very famous story that you all watched in American movies about decision of the Supreme Court to the dismantle constitutionally racial segregation, and you know how much time was needed for the southern state to apply decision of the Supreme Court of the United States, and still nowadays you have the same stories about institutions that are functioning against a certain sector of society. When it comes to this question, it's obviously a common criticism to the gender perspective or to any other perspective that involve minority protection. Minority protection by default means that you departing the idea all the same rights for the same classes of subjects. But the history simply very vividly show us that there is a need for some such protection, because there are numerous examples, and it would be really absurd to come up with a history of example of how women were. You heard a story, one story, how women were excluded, how various other minorities were excluded from even exercising the basic rights that were given to the other majority sectors of the society. So in that sense, this is a rather weak attack on gender-based approach to rights. So I wouldn't say that simply by saying, oh, but don't we want all to be like humans with the same set of rights? Yes, we do want, but exactly because we need not only to be legally equal, but to gain as much as possible of factual equality, there are certain additional rights that are needed for certain groups that were historically excluded from the efficient exercise of those rights.
And extraordinarily brief.
As always.
As usual. Absolutely, it is. Absolutely, it is necessary to do this. So this is a basic concept. You just can't. It's quite simple. You just can't achieve, let's say, justice or equality in any way. It doesn't have to be just male-female gender approaches. Just by changing the law, you have to have some social changes that can be induced by changes in law, but don't have to be induced by changes of law, in order to bring, if the goal is equality, you can say, of course, it's not, my goal is not equality. You can say, of course, my political goal is for women to sit at home and cook. But we are then speaking about a completely different thing, and you should make your goals clear. But if you want to achieve, and if you're convinced that women and men should have equal footing and equal starting positions in a society, then it's not enough to change the formal rules within that society. That's for sure, and this story is the way to see it. Yeah, that's basically it. Right?
Are there some other?
We have a comment. Maybe do you want me to?
Can I first?
Please, Anna.
Okay.
So it's just
Please.
Second, so I will read the comment. In my opinion, I don't think that the law should protect only women. A constitution should protect all people subjected to it, which is that we have in Vietnam. By singling out women, the establishment narrative will be women are weak and need protection, which only address the symptom, women being attacked by men, without addressing men's violence against women, men, and every other gender, even encouraging men's violence to protect women. The particulars on preventing men's violence can be established in smaller branches of law, such as criminal law or law against discrimination.
Okay, just thank you for this comment, but we will have other courses related to criminal law, criminology, so maybe we can leave it for there. But just if I make one comment to combine, Miodrag was talking about gender lawyers. I think more precisely I would name that gender sensitive, gender competent legal professionals, either judges or social policy decision makers or teachers at the law school, etc., etc. But especially judges and lawyers, their gender sensitivity is especially important. And when to connect with this analysis of Bojan, that currently in Italy we have proportionally more female trial lawyers than male. It also speaks not only in Italy but also in Serbia. We have more judges in courts proportionally, but always much more presidents of courts than women, and always they have smaller salaries. The colleague asked how it comes. It comes because they do not generally, on average, they gain lower positions, and plus, if the maternity leave is not very well regulated, or if paternity leave is not, all in all, they get, at the end of the day, they get lower salaries. But to come back to the lawyers in Italy and to compare them with our gender lawyers, or needed or wanted gender lawyers, I was on the at the conference in September, October, where and in Palermo, and there were really there was a great number of very competent and extremely gender sensitive female and male lawyers speaking about refugee issue from the gender perspective, and mafia issue, etc., etc. If we compare, so gender lawyers in Serbia are, that is my, how to say, estimation from these experiences and from many other sources in regards of judiciary in Serbia, that our situation is gender sensitivity within our courts and among lawyers is almost zero. So we are not the best example, and I think that is one of the reasons because of which we really need gender sensitization of higher legal education and promotion of this approach in order that once upon a time we reach what Miodrag mentioned, critical mass of legal professionals, not I would say of gender sensitivity within legal professions in Serbia. Thank you.
Not mass, mass.
Critical mass. Critical mass.
Joking, it's a funny word. No, a comment on what you said. I had a recently talk with a judge of the German Federal Court, and we were speaking exactly about this issue, how many women are among legal profession, and it's almost on like half on average. But then she said most of the practitioners before the German Federal Court are men. So those biggest cases that come to the highest instance are in disproportionate number are represented by male practitioners. So these are the problems that are obviously kind of structural problems, and they go beyond law. So if I had to just make a brief comment on what Bojan said, I don't see problem, especially in modern law, perception of modern law as some sort of oppressor towards women. I wouldn't say. I would say that law was exactly used, at least in a last 50 years, for sure, as a vehicle of reforms for the better status of women in society. But whether this is enough, obviously it's not. And it's weird to expect that everything is settled once you have some written law which is in effect. So that's not the case. You obviously need much more to do, and in that respect, those criticisms that are addressed to law as such, I do not find very reasonable enough or convincing enough. But the problems are with institutions or the people in the institutions. So yes, problem is with lawyers or with other institutional actors, and how to settle those problems, it's a rather difficult topic. I'm also not sure that the simple answer to everything is let's make it gender sensitive, because we we had this discussion last year, so I will not replicate it. I firmly stand by the belief that there are concepts which are kind of gender neutral in a sense. So there is nothing to be brought by gender perspective, so to speak. So we discussed, for instance, the concept of justice as it is, just the form of justice as it is what you learn at the very first year of law studies, like treat equal equally and unequal unequally. So there is no gender perspective to that at all. There is no gender perspective to that at all, unless you want to say, oh, that was said in a time when women were excluded and treated this and that. Yes, but that's not it's not like the formula was invented by Aristotle only to be valid in ancient times. We still use it nowadays. So who will be put in a position of equals or unequals, it depends on the institution. But the very concept, if you ask me, cannot be gendered in any way, but there are concepts that obviously could and should have been gendered throughout the history, and we were mentioning the concept of citizen, for instance. Obviously, it was something which was deeply created in a way that brings the exclusion of women from the political arena. So the answers to those problems also have to be sensitive and nuanced. Otherwise, we will end up with just suggesting that some sort of gender approach is a kind of panacea. It's an answer to all of our vices, which is not. It's only one tool. There are numerous other tools that we have to take into account in order to get some better or fair society.
There were I'll leave you. There were a couple of comments about the reasons for this difference of pay and the discrimination, and I just want to frame it in kind of a different way. There is I wouldn't like you to understand me. There is reasonable disagreement to be had between these positions. One could still reasonably entertain the position of liberal feminism. That's completely okay, but it's just the question of, so when you change this in order to equate men and women, like Miodrag law has been for the most part, when you change it and you make it equal, it is the question of, are you ready to wait for 70 years for law to influence social relations to such a degree that actual equality comes or is instituted? Well, the answer might depend on whether you're a part of the discriminated group or the other group who is not discriminated. I'm quite certain that nobody from the discriminated group would say, yeah, I'll wait for 90 years now for my grandchildren to have the equal social opportunities. That's the first thing. Still, it is legitimate in various political positions to claim, let's change the law and let's wait. Now, another difficult issue is the unintended consequences of regulation. So, whenever you engage into a kind of social constructivism, extreme social constructivist view regarding anything, even gender issues, there is the possibility of significant backlash that can eventually lead to even a prolongment of acquiring a certain social status by a discriminated group. And this is why lawyers are not entirely the best suited to resolve certain issues. Lawyers are usually those guys, girls who only have a hammer, and yeah, everything they see looks like a nail, and that's it. We just hammer it with that nail. When there is something happening, we introduce new criminal sanctions. When there is something happening, we introduce a new constitutional right. When somebody doesn't have internet, we introduce a right to a broadband internet. And it doesn't matter that the line to his house, there is no line to his house, but we introduce the right to a broadband internet and stuff like that. There are other ways of regulating societal relations, of influencing them, that are not legal in nature. Criminal lawyers are often very well aware of it, that you don't bring down amounts of criminality just by raising the amounts of prison time that one spends. Otherwise, the entire criminal law would be death penalty for everything, and we wouldn't have criminality in society. That's obviously not true. So there definitely are various modes of action, but as Miodrag said, law is usually a good starting point in regulating these differences.
So thank you. We will finish for tonight. I hope you had, how to say that, many questions, many controversies come to your minds, and we will have many more those discussion workshops for the discussion. Tomorrow we will proceed with human rights law, gender perspective in human rights law at 5 o'clock. So I hope that our work will go on in this good way. Thank you very much.
You all.
Thank you.